Welcome, everyone, to the Matrix Conversations and Transformations, a seminar series from the Department of Critical Theory and Social Justice in Los Angeles that features innovative scholars, artists, and activists. This event is co-sponsored by the Representation Project, an organization dedicated to fighting intersectional sexism using media. I'm Dr. Mary Christianakis from the Department of Critical Theory and Social Justice, and I'm joined by my co-organizers of the Matrix, Professors Malik Moazzam-Doulat and Caroline Heldman. Today, we are honored to be joined by an outstanding panel of experts on the future of Roe v. Wade. One housekeeping note, you can submit your questions at any time via the Q&A button at the bottom of your screen, and we'll address those at the end of the interview. And now my colleague, Professor Moazzam-Doulat, will introduce our panel.
Hi, everyone. So first, I'd like to introduce David Donati, who's a staff attorney at the ACLU of Texas. David's a native Houstonian who joined the ACLU of Texas in January of 2019 as a generalist civil rights attorney through the Samuels Family Legal Fellowship. Prior to joining the ACLU of Texas, David clerked for the Honorable Robert Pittman in the Western District of Texas and worked as a litigation associate at a large New York City law firm where he focused on public and private international law. He holds a BA from the University of Texas and a JD from Harvard Law School, where he was an editor of the Law Review. Council member of West Hollywood, John Erickson, was elected to the West Hollywood City Council on November 3rd, 2020, with the commitment to uphold the city's founding vision for forward-thinking, diverse, and a tolerant community. Councilmember Erickson first planted roots in West Hollywood in 2010 when he was selected to intern for the West Hollywood City Council. The internship set him on a path that connected his work for social and economic justice with his passion for public service. Councilmember Erickson previously served as a legislative representative at LAX, that's Los Angeles International Airport, and is currently the Director of Public Affairs at Planned Parenthood Los Angeles. Councilmember Erickson received his PhD in American Religious History from Claremont Graduate University and a dual master's degree from Claremont Graduate University. He graduated from the University of Wisconsin, Oshkosh with a BA in English and Women's Studies. Our third panelist is Sarita Fontanesi, who is the executive director of Emerge Texas, the nation's premier organization that recruits, trains, and provides a powerful network for Democratic women who want to run for office. An activist for Black women and femmes, Sarita assists systems, organizations, and individuals in making subtle changes that have big impact so that they can thrive in a more holistic and culturally competent way. Healing generational wounds caused by centuries of systemic injustices requires change on an individual and a macro level in order to create new and more supportive path forward. Through the use of practical and energetic tools, Sarita disrupts old ways of thinking that no longer serve the highest good, creating space for productive practices. Sarita focused her studies on community organizing and social change at the USC School of Social Work. And with that, I turn it over to Professor Heldman.
All right. Well, it is my great pleasure to jump into this panel of experts. So the Supreme Court establishes abortion as a fundamental right in 1973 with the Roe v. Wade decision. And since that time, it's been half a century, right? Anti-choice advocates have worked diligently to overturn this right through many lawsuits, through hundreds of state restrictions, and an elaborate effort to get anti-choice justices on the Supreme Court, which has happened, right? So this is a long-term plan, and much of it has now come to fruition for anti-choice activists. A recent poll finds that 1/3 of Americans, only 1 in 3 Americans wants to see Roe v. Wade overturned, which means that 2/3 of Americans do not want this fundamental right overturned. And yet the Supreme Court has upheld a Texas law recently, which is well out of step with public opinion. So David, let's get started with you. Can you please give us a primer, an overview, get us up to speed on what's happening with Roe and the Texas case, and maybe talk a bit about the legal path that has gotten us here, the legal path to dismantle Roe?
Sure. Thank you so much for having me on. I'm very happy to be here. I'm probably going to give somewhat of a long-winded answer because I think it's a complicated question with a lot of moving parts. But just to lay the groundwork as to where we are. So this year, there are 2 really important things happening in regards to the fundamental right to abortion. The first one is one that we all saw coming. It's one that we've all prepared a little bit better for. And that's that the Supreme Court, in a case called Jackson Women's Health Organization versus Dobbs, has agreed to take up, for the first time since Roe versus Wade, the question of whether a state can ban a pre-viability abortion. So that means before a fetus is in and of itself viable, i.e. it can stay alive with or without medical support, can a state all out ban a woman's right to choose whether to carry forth their pregnancy. And when I say a woman, I do acknowledge that people of all genders can have children. So that question has been taken up, and that case is a little bit more complicated than that as well, because it also concerns, it in some respects concerns what Mississippi has done by banning any abortion after 15 weeks following a woman's last menstrual period. So that's how we calculate the gestational age of a fetus, and that, you know, but the state of Mississippi also has done something similar to what Texas has done, which is attempt to impose a 6-week fetal heartbeat ban, which means 6 weeks after the last menstrual period, way before most people know that they're pregnant, 2 weeks after the first missed menstrual cycle, banning the ability to have an abortion. So the Supreme Court has taken up that question. In addition, there are a number of other Mississippi regulations that go to whether a person can actually meaningfully access abortion care. So that includes extremely restrictive regulations on abortion providers that aren't applicable to other providers of medical services. And the effect of those restrictions is that there's actually only one abortion clinic in the state of Mississippi. But that's something that states do. They regulate the provision of abortion care, which fundamentally reduces access to abortion, notwithstanding that it's a fundamental right. But on the one hand, you have these bans, which is just saying entirely abortion is not legal after this gestational age. And on the other hand, you have these restrictions which go to the providers and what they can do. You have so many states like Mississippi and Texas that require informed consent, the provision of certain kinds of information, mandatory waiting periods. So for example, a person has to go to the healthcare facility at least twice in order to get an abortion. And often providers are mandated to sort of identify some kind of state propaganda or some state provided information as to the choice that they're going to be making with their doctors and their families. And then there are also things like judicial bypass requirements for minors who are seeking abortion care. So that is a case that the Supreme Court has agreed to hear and will hear this fall. And that has been ongoing for a while. We've sort of known the alarm bells are ringing for a while now. But then on top of the mix, Texas, the state where I'm working, has devised a sort of ingenious scheme to go around all of that. So where Mississippi did it directly because they wanted to confront the question at issue in Roe versus Wade, Texas has banned an abortion after 6 weeks following a woman's last menstrual period. And it has, instead of saying the state will enforce that law, it has entirely delegated enforcement to private parties. So any person can sue any provider, any person who aids and abets, which just means helps the provider, or any person who intends to facilitate an abortion, to get a mandatory block of that procedure, as well as a mandatory minimum $10,000 of statutory damages. And the law operates in a lot of extremely sinister ways, which I'm happy to talk about, in that it fundamentally alters the rules of legal procedure to make it so that these cases are impossible to defend. So those are two issues that are ongoing. There's Mississippi's ban, as well as additional restrictions on abortion providers. And then there's Texas's ban, which is enforced in this ingenious way. And so from there, I'm just going to step back a little bit to lay the groundwork, which is 1973, you have the case Roe versus Wade, which stands fundamentally for the proposition that the right to abortion is what we call a fundamental right. It's something that inures in all of us. It goes to our human dignity. And so like other fundamental rights, for example, the right to be free from incarceration or the right to free speech, it is a right that can be violated only subject to what's called strict scrutiny. So it has to be like the absolutely necessary restriction in order to accomplish a compelling government interest. But the Supreme Court said the right to abortion, which is the right to privacy, the right to bodily integrity, cannot be infringed before viability. So that's 1973. You fast forward a little bit to and the Supreme Court revisits the question in a case called Planned Parenthood versus Casey. And that case was not about a ban to abortion altogether, but it was about a series of restrictions that the state of Pennsylvania imposed on access to abortion. And so those were informed consent requirements, they were limitations on clinics and providers, they were For a minor, you had to get one of your parents to consent and agree to the procedure. And for a married woman, she had to prove that she had notified her husband that she was seeking to terminate the fetus. So the state of Pennsylvania passed these laws, which applied to all abortions before viability of the fetus. It was just a general restriction. And so the Supreme Court takes up the question again. And it was a very divided opinion. It was 5-4, which we're now very familiar with. And the Supreme Court said, on the one hand, Roe versus Wade is still good law, that a person has a fundamental right to an abortion before viability of the fetus. But what the Supreme Court did, though, was it said that restrictions on the right to an abortion are permissible under a much broader series of circumstances than the court contemplated in Roe versus Wade. So it took that strict scrutiny formulation. It has to be necessary to a compelling government interest, and it imposed a different standard, which is called the undue burden standard. And basically the question is this restriction that a state is putting into place a substantial obstacle to the access of the right to abortion, but it allows for a lot of judicial flexibility. And so what we've seen in the wake of Casey is that different states have, for the past several decades, tried to figure out what is the most restrictive set of requirements that they can place in front of access to abortion toward the end of eliminating the right altogether. This is a very ideological fight, and the battle lines are drawn. But the goal of several state legislatures, including Mississippi and including my state of Texas, is to eliminate the right of abortion, and it is to do so either within the parameters defined by Roe versus Wade and Casey, or to do it just in flagrant violation of them. So where are we? The Mississippi case involves both of these questions. So this is the first time Mississippi passed what I call straight up bans. I know that's not the term, but it's an actual gestational age ban. So it on the one hand said before 15 weeks, you can get an abortion, after 15, you cannot. And then it subsequently limited that to 6 weeks. But the Supreme Court is taking up that fundamental question, can you just have a ban on pre-viability abortions? So that's monumental. That's the first time in 50 years that the Supreme Court has agreed to take up that question. But the Mississippi ban also implicates those Casey questions about undue burden, because we're also looking at whether the regulations that Mississippi has put on abortion providers, and there are a lot, I won't get into all of them, but they include, for example, those 24-hour waiting requirements. They include bans on telemedicine, which don't extend to any other provision of care. And that's also true for medication abortion, not just procedure abortion. They have a series of very restrictive regulations that inure only to abortion providers and to no other providers of healthcare, which have had the effect of limiting the number of clinics in Mississippi, and in several cases, shuttering abortion clinics in a state altogether. So both of those lines, both the Roe and the Casey line, are at issue in Mississippi. The Texas case, I think, comes as a surprise to everybody. The Supreme Court probably wanted the neat challenge in Mississippi with all of the briefing and oral argument, pomp and circumstance, amicus briefs that comes with the Supreme Court case. Texas just went around all of that. And what Texas has done here is it passed this ban. It said an abortion is a criminal act in the state of Texas, because the state of Texas has, for the past several decades, had these criminal restrictions on access to abortion. It said, notwithstanding Roe, all of those laws are still on the books. And now it has created a series of prohibitions and reporting requirements on physicians and providers to eliminate access to abortion after 6 weeks last menstrual period. But what the state of Texas has done here, which is significant, is it has said, although it is prohibited, we as the state of Texas, no state officers, no employees can enforce this ban. Instead, it creates what is called a private right of action, and it says any person, and as we've seen, that includes any person in the state of Texas, it includes any person outside of the state of Texas, can sue the provider or aiders or abettors to block the procedure. The only purpose of doing it this way is that it makes it harder to review the constitutionality of that act. And the only reason that's true is because of a series of legal fictions that we have in court about when you can sue state actors. There's this principle called sovereign immunity, which ruins my life every day. But it basically says that you can't take the sovereign here being a state like Texas or Mississippi, or a person acting on behalf of the state, you can't take them to court except when you are trying to block them from violating some kind of fundamental or constitutional right. But Texas here is saying, well, the state, the sovereign, is not the one that's violating fundamental rights. It is the private enforcers. It is this mass of amorphous people who may or may not ever sue that are actually responsible for bringing this act to life. It has completely shuttered abortion care in the state of Texas. So we now have one doctor, Dr. Alan Braid, who has openly defied the abortion restriction and provided care. And other providers may follow suit. That doctor has been sued by individuals out of state, and we're going to see how that goes. But I do think that case raises a few really troubling questions. The most important of which is, what are the devices by which a state can violate our fundamental rights? And I think here we're talking about abortion, but there aren't actually any logical limitations to what the state can regulate in this way. The state can say, for example, we're not going to enforce racially restrictive covenants, but private parties can enforce racially restrictive covenants. An example that's been thrown around, for example, is what if the state of California, where you all are sitting, wants to ban guns? And it says, we can't ban guns because the Second Amendment says that we can't do it, but we're going to create a private right of action so you can sue your neighbor. And we're going to incentivize people to sue their neighbors by creating a $10,000 bounty. And so those questions, they shouldn't be complicated, right? It should be that a state can't delegate its enforcement power to private parties and violate fundamental rights in that way. But because of the ingenuity of this procedure, the courts, in particular the Fifth Circuit Court of Appeals, where we are, and the Supreme Court, have been hesitant to block the law. So the law has had its intended effect. And the one other thing I'll note about this is just how quickly all of this is happening. So this is really the brainchild of a few anti-abortion activists in the state of Texas who started in 2019 advocating for local ordinances, basically saying, within this locality, abortion is illegal, but we're not going to allow the locality or the state to enforce it. We're going to allow people to sue. And that model has flown from local jurisdictions to the state of Texas. And now we're already seeing different states having their own copycat bills. So the state of Florida, a representative today, filed a bill that is substantively identical to the Texas restriction here. So I think that we're going to continue to see this model, certainly in the abortion context, and I would not be surprised outside of it. And hopefully that's helpful.
Yeah, thank you. Very helpful, David, in laying out the landscape of what's happening right now and what's going to happen December 1st when the Mississippi case is heard by the court, or just the fact that it is being heard by the court and how significant that is. Sarita, now moving on to the activism, what is happening on the ground in Texas right now? How are activists pushing back against this $10,000 bounty law?
Yeah, we've seen a few different approaches. So looking at kind of the top level, included in this idea of anyone who aids and abets an abortion, that includes the Lyft driver who was just answering a call. So we've seen Uber and Lyft both really set up legal funds for their drivers should any legal action be taken against them. We've seen folks like the ACLU, Planned Parenthood, their political arm, Planned Parenthood, Texas Votes, and various organizations really step up, one, to, if the bell wasn't loud before, really ring the bell and bring attention to what exactly this law does. Often the way that these laws are written and presented, it can be really misleading, as well as just flat out leaving whole chunks of things out. We saw that happen with the voter suppression bill, which we can talk about later, of folks just not mentioning whole pieces that do really big damage. So the first thing is information and combating disinformation. Really making sure that people know, no matter what, as of now, abortion is not illegal. This is incredibly restrictive, right? At 6 weeks, as David said, that's only 2 weeks after a woman's missed period, or a person with a uterus's missed period. And that's if they're regular and if they're on a 28-day cycle. Like, there's so many things in that. So one, that combating misinformation and making sure people have the correct information they need. Then we've got some type of mutual aid organizations like Jane's Due Process, the Bunnies, and various other folks who are raising money for folks to seek abortion outside of Texas, for folks to deal with any legal issues that might come up, to make sure that there's some type of safety net for folks. And then in the political space, especially in my work, I'm working predominantly with candidates or electeds. We're really thinking about how do we, stop this where it's at. And then how can we look ahead and think long term? These issues start at the local level. Earlier this year, back in May, Lubbock, a city in West Texas, had a measure on their ballot in their local election to declare Lubbock a sanctuary city for the unborn. And so, which is a big statement to make. And essentially what this ballot measure did was a lot of what SB 8, this anti-abortion bill, is doing. So it laid groundwork and informed state legislatures that there might be a place and a space for a bigger, bolder piece of legislation. So really remembering when we've got these elections on November 2nd here in Texas, that every single vote, every single election matters, and making sure that we are getting folks informed about what exactly is on their ballot, because it starts at the local municipal level. So that's kind of the overview of what's happening here and how we navigate this moment. As David also mentioned, there will be continuing challenges to this legally, and figuring out ways to circumvent, to adjust, to expand these laws so that folks are able to get access to the care that they need, and in a way that is equitable and affordable and accessible. But we right now are really focused on how do we manage the needs of people right here, right now in this moment.
Thank you, Sarita. John, shifting gears a little bit to a bigger scope, talk to us about the importance of Roe and the importance of abortion in intersectional gender justice in the US.
Well, thank you so much again for putting on this panel. It's an honor to be with everyone on this panel and all the expertise. We just are changing the world, and I'm so thankful to all of my colleagues in Texas. That's where all the work is going on, and seriously, we can speak from a very privileged space here in California, but I know what it's like to live in a redder state. I'm from Wisconsin. I'm from Ripon, Wisconsin, the birthplace of the Republican Party. I always say the Abe Lincoln Republican Party, so a little bit better. But most importantly, the right to privacy is the crux to so many constitutional laws. When we look at the city, I have the great privilege of representing the city of West Hollywood, a very forward-thinking, progressive LGBTQIA city. The right to privacy is embedded in gay marriage, gay and lesbian marriage, to you look at sodomy laws with the right to privacy, to all of the really nuanced constitutional cases that we have seen essentially progress through the Supreme Court because state laws and state houses were doing exactly what we have here in reverse with access to safe and legal abortion and what they can or cannot do with people's bodies. So when we look at the right to Roe, it's what we've all been saying for many, many years, probably day 2 after Roe was passed. It's that don't let up. This is it, right? And I always say, as a man in feminism, it's, if you think they're just coming for some of us, you've been missing the whole show. And so when we get done here, and I, sadly think that when the Supreme Court does overturn or essentially gut Roe and make it essentially useless, which has always been the strategy, I think leading up since Bork didn't get appointed to the Supreme Court with this intense judicial takeover, that I think as Democrats, I identify as a Democrat, but have to almost admit that we lost that battle, and we have to, I think, refigure out how we do that. But most importantly, Gay marriage is next. Other civil rights laws are next. We're going to talk about voting here, but that's exactly how you chip away at rights and what we do and how we can advance anything. We're seeing an extreme partisan nature in state houses, but across the country. And, you know, it's really interesting that a Supreme Court justice is wondering why the Supreme Court is so partisan. And she's very, very worried about that. And I just have to ask, you know, I don't know what world she's living in, but then again, she's a white woman from Indiana. So I guess I have my answer. But more importantly, I think that, you know, a lot of people need to wake up, a lot of men need to wake up, and a lot of people in cisgendered, you know, more heteronormative spaces need to understand that the rights that they think are safe and secure will be on the chopping block, because I just turned 36 and I don't think I'll see any type of a Supreme Court that matches the ways in which we have anything of which we've had in the past, probably until I'm much older and not willing to acknowledge how old I am at that time. So I think that we have a lot of work that we have to do with intersectional gender justice. And this isn't just about women leading the fronts anymore. This is about every single person we know, regardless of where you sit in life, standing at the front of the lines and ensuring that equality under the law and access and decisions about what someone can do or say over your own body and your own autonomy is on the line.
Thank you, John. And I know David will be joining us in a moment. I'm sorry to put you on the spot, David. I am wondering, two-part question. First, do you agree with John's assessment that the Mississippi case that the court's going to essentially gut Roe? And the second part of the question, can you talk about how these restrictions in particular are disproportionately affecting women of color, poor women, immigrant women?
Absolutely. I think it's hard to read the tea leaves. I think it's a little bit difficult to know what the Supreme Court is going to do. And I say that from a place of deep skepticism, which is, I think that a lot of us talk about Roe versus and a lot of the public probably consider it as sort of like a binary. Does Roe stand? Does Roe fall? And that's the question. And the way that I see it is actually a little bit more complicated, which is that for the past 50 years, Roe has been chipped away at in substantial ways. And the ways that it is being undermined are so evasive, complicated, nuanced, that to me, the question is less, will Roe versus Wade be precedential? Will it continue to be a case that is considered to be in effect? And the question is more, will the judiciary be a meaningful place to vindicate the fundamental right to an abortion? And I think asking that second question, the answer is almost certainly no. Which is very unfortunate. And I say that having recently been in the Supreme Court on this issue, where we filed our challenge to the Texas restriction a couple of months before the law went into effect. The district court was scheduled to hear an preliminary injunction, which means to actually block the law and stop it from taking effect before the ban took effect on September 1st. And the Fifth Circuit Court of Appeals, which is the intermediate court that we respond to, it took away the case and it has held it ever since. And we went to the Supreme Court to say the Fifth Circuit has taken this case and we need it to be heard, because otherwise the state of Texas will ban abortion. There will not be the right to abortion in the state of Texas. And the Supreme Court, 5 votes to 4, declined to act. And it declined to act throwing up its hand saying, we have substantial questions about its constitutionality, etc., but we're going to allow the law to take effect. And I think a reasonable commentator can have mixed feelings about that. You know, on the one hand, they haven't come out and said there is no fundamental right to abortion, there is no fundamental right to privacy. They haven't taken that step, but they have allowed, in effect, in reality, on the ground here in Texas, for that fundamental right to be meaningless, to be deprived through an ingenious state device. And that, I think, is deeply disappointing. And it may even be more troubling than a decision that outright overturns Roe versus Wade, because it is the judiciary sort of maintaining its legitimacy through ostensibly adhering to its precedents, not overturning the decisions that have been in effect before, not undermining 50 years of pronouncements by it and by other courts. It is not doing that, but in effect, through what is called the shadow docket, it is allowing the exact same outcome to happen. And I would not be surprised if I would fully expect, I think John is right, that there are at least a few justices on the Supreme Court who would love nothing more than to write an opinion detailing why Roe versus Wade was wrongly decided in 1973. I think that there is a non-trivial number of justices who would like to do that. I think the question is almost, will John Roberts prevail and allow Mississippi to gut the right to abortion without overturning Roe versus Wade? So I'm not a gambling person, but if I were to bet, I would say that we're going to get a deeply divided court that on some level reaffirms the fundamental holding of Roe, but also allows Mississippi to undermine the right to abortion in several meaningful ways. And that's not a satisfying outcome. It won't make the same splash, but I think for women, for people with uteruses, it will have the same effect. And likewise, I think that a lot of the toxic effects on the right to privacy that John was talking about, those exist nonetheless. I think Roe was very strong for the principle that this is a right to bodily integrity. This is a right to whether and when the state can regulate the decisions that we make about our healthcare, about our family planning, decisions that we make with our doctors. And in several ways, Casey it made the first of 1,000 cuts as to that right, because it said, well, sure, there's the right to privacy, but what about the state interest in X? What about the state interest in Y? And so I wouldn't be surprised if what we get is just a reshifting of the balance so that we can continue to talk about a right to privacy, but we don't have to honor that in our actual commitments on the ground. And I think you ask the right question, which is, what does this mean for people of color, for low-income people? And I think it is substantially disproportionately felt. So the reality in the ground in Texas is that anyone after 6 weeks cannot access abortion care in the state of Texas. But that is felt very differently for people who are low income, who can't afford to go out of state for their procedures. And just to put a fine point on that as well, I think, so there are amazing organizations doing work on the ground to help gather those funds, to help particular communities access abortions that might otherwise be unavailable to them. But even with the work of great organizations like Frontera Fund, like the AFIA Center, you may have the money to travel, but you may not be able to take time off work. You may not have your childcare expenses. And I think that that's a part of the story that goes overlooked. And also, the effect of the Texas law is not just being felt in Texas, it's being felt nationally. And so we submitted declarations in the federal government's case on the Texas abortion ban, talking about what was happening in Oklahoma, for example, where you have substantial numbers of their clinic capacity being taken up by Texas patients. New Mexico, it's the same story. And so it creates this leapfrog effect where if you want to get an abortion, you can't actually go to the neighboring state. You can't go to Oklahoma. Louisiana has almost no clinics anyway because they've got the right to abortion in so many ways. You can't go to New Mexico. You have to go to Kansas. You have to go to Ohio. And so it becomes more and more prohibitive as time goes on. And the more states that do this, the fewer clinics there will be. And what is happening is that even though those states may or may not be able to provide, we have backlogs. And all of that is extremely complicated. And when you layer on top of that mandatory waiting requirements, clinic revisitation requirements, it just becomes extremely prohibitive, such that you're only going to get people of substantial means with the ability to have their childcare resources taken care of, with the ability to take time off work or work remotely, accessing abortion care. And then I think another big piece of this story, of course, in Texas, we have a very strong correlation between ethnicity and income level. So this affects Latinx and Black women substantially more than it affects white women. But in addition to that, we have substantially disproportionate maternal mortality rates. It is just substantially more dangerous. if you are a person of color in the state of Texas to carry pregnancy to term, which is in intention and effect what is happening in Texas. So this is devastating for Texas communities. It is devastating in particular for people of color, for low income communities, and it is something that we are seeing spill over into other neighboring states. And I think that the effects of that are going to continue to ripple out and grow.
Thanks, David. Sobering look at what comes next and what's happening now and the disproportionately intersectional effect that this is having. So Rita, let's talk about politics. We have a supermajority, conservative majority on the Supreme Court because of the stolen seat, right? And in fact, if you look at how that maneuver took place, there were preachers across the United States who were, preaching from the pulpit in 2016 and saying, you might not like Donald Trump, evangelical folks, but hold your nose and go and vote for him because they're going to hold that seat and he's going to put somebody on who's going to overturn Roe. And sure enough, here we are, right? So we have a Supreme Court that is wildly out of step with the American public when it comes to a lot of things, corporate rights and responsibilities, civil rights, abortion rights, you name it, the climate crisis. We also, though, have some states that are doing this, right? So we see voter suppression laws being enacted across the United States. And this is a very long way of asking how this is affecting states in terms of representation. So what role are voter suppression efforts playing in advancing extreme agendas, for example, in Texas and Florida?
Yeah, it is absolutely a ripple effect. To start, so many things. To start, here in Texas, Democrats in general represent, if you are crunching the just raw numbers, a little more than half of the state. It's about 53%. And the Democratic Party here in Texas is majority minority, and not quite at parity in terms of gender, but it is very diverse, moral of the story. And then when you look at our state legislature, which only about a fraction of it, it's a quarter to a third of it, is represented by folks who identify as women, we have no majority in our state legislature amongst Democrats. No Democrat holds a statewide office here in Texas, which I know can feel really heavy. And so there's this real disconnect between who is in power, who is making these decisions, and who is actually impacted by them. Going off of what David was saying, Black folks only make up about 12% of the population here in Texas, but 30% of people seeking abortion identified as Black. So that's a real incongruence. And it's not because Black folks are, leading some life where they're needing an abortion. It is because of a lack of access to healthcare, a lack of access to education, to job security, to all of when I say a ripple effect, all of these other things are impacted, and carrying a child to term will have another impact on those things. So if you're already disproportionately not getting access to the things that you need, and now you're having to take on the burden of a child, perhaps another child, a common conservative talking point is, well, you'll think differently about abortion once you have children, and it ignores the huge swath of people who already have children and are choosing to have an abortion because ultimately is a form of health care. It is their choice, their right, and how they want to manage their health and their life and their well-being. So bringing it back to politics, though, what we have seen is the power of the state legislature. Often folks can, unless you're in a California or New York and Texas in this case, folks often forget about the power that their state legislature has, because we're looking to Congress to tell us things. We're looking to our local mayors and city councils because they're the people that we interact with the most. And the state legislature can sometimes get washed out. But all of this current moment has been led by the Texas legislature with Greg Abbott, our governor, at the helm. Greg Abbott has been in Texas politics maybe as long as I've been alive, for quite some time now. He started as an attorney general, moving through to governor, and has been serving as governor for quite some time. And what we saw in 2020 is, there was the big hope that Texas was maybe going to go blue. And while we might not have gone for Biden, we did see our highest voter turnout in history. Particularly Black voters turned out at about 97%, which surpassed the national average of 93%. We saw huge shifts, not just within the urban cities. We saw suburbs and rural communities engaging in democratic work. And turning out to vote in just in ways that we hadn't seen before. And that's really scary to a group of people who want to hold on to absolute power. And Republicans have had a pretty strong hold on Texas for quite some time. But I tell people all the time, Texas is not a Republican state, it's a non-voting state. And last year we saw that Texans can and will vote. And so now what we're seeing is a backlash to that, is Republican lawmakers recognizing the power that voters can have in this state, the power that voters do have in this state. And so that's when we start to see a rollout of increasingly restrictive and oppressive laws. And I include not only the anti-abortion law, but also the voter suppression law, SB 1, that has rolled out. We just started redistricting on Monday and got a first draft of maps, and they're not looking great right now. And so, it's going to be a lot of back and forth in that space. And it's because you have a group of people, again, who are wanting to maintain control and power that was never really fairly given. And the only way to do that is to continue to block certain folks, certain groups from being able to access voting. So like in Harris County last year, we saw 24-hour voting, we saw drive-through voting to try to manage the pandemic. Texas does not allow vote by mail for just anyone. It's pretty exclusive in that way. And so trying to find ways to work around a global pandemic that's killed, hundreds of thousands of people, various places got creative. And so something like 24-hour voting in Harris County saw really great results, because now people who don't work a typical, whatever that means, 9 to 5 and can't go vote before work or after work, who maybe work a graveyard shift, who maybe have family members or children or people in their lives that they have to be responsible for, could find a time that worked for them, near, convenient, off of public transit, so that it's accessible as possible to go out and vote. Harris County turned out in huge numbers, and Republicans saw that as a threat. And so now vote by drive-through voting and 24-hour voting no longer allowed at this current moment. And so we're seeing this I've been describing it as hopefully a death rattle of, again, the folks seeking to really hold on to power in an absolute way, in a way that only lifts up some and not all. And as scary and as difficult and as overwhelming as it is, we have to remember it wasn't always like this, and it doesn't always have to be like this. And the way to change that is by supporting folks who want to run for office, who have progressive values, who represent marginalized communities, right? When we take care of the most vulnerable community member, we're taking care of the whole community. When we take care of folks who are most marginalized or who are most impacted by the various intersections that they live at, then we make sure that everyone gets their needs met. And so who better to be making those decisions than folks of color, queer folks, folks with disabilities, folks who represent communities that are often overlooked. that's, I mean, that's the work that we do in Emerge Texas. That's what the work that a lot of our advocacy groups is supporting candidates and candidate development and recruitment, so that we never have to hear there's no one to run for that. Because there is, I guarantee you, there is someone that you know in your community that would make a great local leader, that would make a great state leader, that can help and make a change. But they can't do it if they don't have the resources to support them, if they don't have the community to back them up, if they don't have the advocacy organizations to uplift them.
Thank you, Sarita. Okay, so that's my last question. You just answered that. The last question I wanted to throw to everybody, I just want to reiterate, like, encourage people to run for office. Local leaders are all around you, like good local leaders, encourage them to run and maybe get them connected to Emerge in their local area. John, as a great local leader, what is the one thing you think people can do right now to protect abortion rights?
Well, get loud, number one. I mean, that's all you can do. I mean, get loud, get proud. In one of my hats, I'm organizing the Women's March again here on October 2nd in Los Angeles. I've been doing it for what seems like forever now, since the first one way back when. But we're going to be marching for reproductive justice on October 2nd at Pershing Square in downtown Los Angeles. But it doesn't stop there. Cities like West Hollywood is the first pro-choice city in the country way back when the Pro-Choice Cities campaign came back. And we just passed a resolution this past Monday calling for the reestablishment of a pro-choice cities campaign. And we're going to have to do this across the country in a way, because if the worst comes to be, as David and Sarita have been talking about, we're looking at, we don't know what rights you have in what state because of how it's been handled. And so ultimately what we all have to do is then do something. I know Sarita is going to love this information, is we have to support candidates who may not actually live in our state, county, or local city. Here in West Hollywood, I think I can safely say it's a very progressive city, LA County, all these other places, but we still face 40 days for life, other really restrictive individuals. I mean, there's always that threat. We can never say that it's somewhere ultimately safe. But what we have to do is we have to go to places like Arizona. If you can, go to Texas, go to the places around you, but boots on the ground, march, get those people, because Sarita hit it completely on the head. It's that Texas is a non-voting state, but the voters are there. We just got to get them to the polls. And these restrictive voting laws, these laws and the ways in which we put barriers to access to your constitutional right to vote and have your voice be heard, is something that we have to do and we need to be doing. And so however you can call your grandma, your uncle, your cousin, your best friend's friend in whatever state they got to do, sharing your story is the most important way. That's how Planned Parenthood always does it. Sharing your story. A lot of people don't oftentimes know if you've been to a Planned Parenthood or if you've ever gotten this type of care. When the defunding campaign was going around before I worked at Planned Parenthood, I shared that I got my first HIV test out of Planned Parenthood in Madison, Wisconsin, because I couldn't go to my doctor in my small town state where everyone knew everyone. And yes, HIPAA exists, but let's be real. And the ways in which I got that type of care, and that changes hearts and minds. So get loud, get proud. If you can financially give money, please give money. But if you can put your boots on the ground and knock on some doors, I think I know a great organization called Emerge that will take you on and show you how to do it. And run for office. To all the women and LGBTQ people here, it takes a lot of times to tell you to run for office. I think the magic number is 6 for women at the moment, 7 now. So here's your first one. If we could get everyone else to say it, we might get to 4, but you are the change we've been waiting for. This is the moment. This is the time. This is the time to make sure that you have a voice at the table when everything is on the line. So run for office and get loud and get proud.
All right, so gender and non-conforming individuals and women run for office. That's the second time you'll hear, or third time you'll hear it. I'll pass the baton to my colleague, Professor Moaz Amdullah.
Hi there. So let's take a question from one of our students who asked this question. Since we've already talked about what kinds of voter suppression we're likely to see, is there a COVID conscious strategy in the works to get a supermajority of BIPOC and low income voters safely to the polls in the event that the government removes voting booths in key areas again? And I suppose, Sarita, that question is for you.
Sure, happy to answer. Yes and no. In terms of any state government strategy, no. Our governor has banned mask mandates, has, ended, expanded UI resources. So, this state is not being conscious of COVID. A lot of local Democratic Party chapters, as well as the National Urban League and the NAACP have been doing, specifically within Black communities, have been doing a ton of work around organizing and getting rides and getting masked and making sure that people can be as safe as possible, helping anyone who is eligible for an absentee ballot to get through that process. So some of the local groups are, it's hard to enact statewide strategy because we are a giant state and every county has its own flavor of things. But yeah, there's definitely some local efforts to try to make sure that if people want to vote, they can get there.
Thank you. So we will send out links to the organizations, to Emerge and to the other organizations that have been mentioned here, to all the registrants with the video link, and you can share those as you'd like. And one of the links we'll send out is from one of our viewers, which you can see now if you click on the Q&A, I believe. Yes, so we'll put this link for the brief, the amicus brief for Dobbs versus Jackson Women's Health Center. We'll send that out with the links and you can take a look at that. And we'll gather, good ideas and links that have been talked about already and those that have not from our panelists. Professor Christianakis.
Yeah, I wanted to follow up on the idea of privacy for just a moment, and especially in relation to HIPAA and the responsibility of the medical community. And this is probably a question for you, David. What can be private? What is the medical community doing about this? Are they asking fewer questions so that they don't have to reveal certain answers? Like what would the law tell us around privacy and HIPAA?
It's a complicated question because I think that there are different regulatory regimes at issue. So on the one hand, the abortion bill in the state of Texas actually requires a lot more invasive questioning and analysis and record keeping and reporting. And so at least as far as the state abortion ban is concerned, it chips away at the right to privacy. But different medical associations in Texas have come out very forcefully to say that this is just a huge violation of the doctor-patient relationship. And I think one of the very complicated questions that the Texas abortion ban implicates, and I think it's honestly one that our legislature didn't think through or they don't care, is any person can sue any provider or an aider and abettor for an illegal abortion. And one of the fundamental questions is, how do they prove it? If they go to court and they say a doctor has done something illegal, how do they know? I think that is a question that is, if you're looking at HIPAA, which is regulations on the disclosure of medical records and documentation, you have to ask yourself, how can a person in Amarillo or in East Texas know about my abortion in Houston or Austin? And how can they prove up that the abortion happened after 6 weeks or detection of a fetal heartbeat? They never answer that question. And I think it's one that the gamble is that they'll never have to answer that question. I think a very important part of the Texas abortion ban is, and I think that this is something that we're going to see more and more, and we're going to see more and more of it as we become more hyper-partisan and polarized, and as states try and outsource more and more of their rights violation to private parties. It is, how do these things actually work? And if you're a lawyer like me, that can be agonizing because you're looking at HIPAA, you're looking at the regulations, you're looking at the rules of civil procedure, and you're asking yourself, how does one of these lawsuits actually make its way through the court system? But I honestly believe that the legislature's intention, and what we've now seen, that a provider has provided an abortion in the state of Texas, and the anti-abortion groups have declined to sue at this moment. What they're saying is, well, we'll see how this goes. We'll continue to see how this plays out. Because right now, which is a ban on abortion, without ever having to justify themselves, without ever having to go to court and file a single paper. And they do that because they know that if they go to court, they should lose. So that is the gambit. The gambit is they can ban anything that they want. They can create the most punitive and restrictive enforcement regime that they want. They can chill the exercise of our fundamental rights. And I think this is something that goes to the right to abortion. It goes, until I believe that homosexuality is still criminal in Texas. It's just that since the early 2000s, since Lawrence versus Texas, the state can't enforce it. But could the state penalize all of that disfavored behavior and just create this enforcement regime without even worrying what are the nuances here? How can we cross our T's and dot our I's? But they don't actually care. And I think we see this in a number of different contexts. We see this in voting. We see this in border security. We see this in immigration regulation. It is act violently, act oppressively, and then answer questions later, if at all. And that, I think, is one of the really troubling parts of this law, because you're right, that there are so many ways that this law is hugely violative of our right to privacy in restricting access to abortion. But I think that they haven't thought it through and they don't really care.
And quickly, I just want to add on to what David said. We've been here before. Roe started in Dallas County. The woman in the case, known as Jane Roe, was challenging her local DA. So Texas has been down this path before. And I think there's two things. One, we have to hold on to that we've been here and we've gotten through it and we found a way to the other side, making this huge precedence with Roe v. Wade. And then two, that the same people involved in 73 are the same people almost identically involved now. And so that, again, that goes back to my point of earlier of this is a bit of a death rattle of folks trying to Hail Mary, last ditch effort, hold on to some restrictive power and authority. So just wanted to add that context in.
And let's also not forget that this is all about control, right? That if the heteronormative white patriarchal elite, who get to decide what's over and good for people of color, people of different gender identities, LGBT sexualities, all the things, immigrants, the list doesn't stop there, right? It's about control and understanding that power. And that's ultimately what this conversation is about. It's breaking that final construct of who has control over how we live our lives. And if we can finally break that system and determine that, by the way, that's us, that is the ultimate threat to the ultimate power that we're always trying to dismantle. The master's tools cannot dismantle the master's house. And ultimately right now is we're creating our own new tools through grassroots or other actions, and we're trying to do it. And they know we're coming for it. And they know ultimately, probably in the end, we will win. It's just how much of a rattling of the cage can they continue to do while they try to chip away at our fundamental rights.
Okay, well, I think we are out of time. We've hit it just right. This was, thank you so much for sharing your wisdom and your experience and your knowledge with us. We will be sending out links and places where you can help out and ways you can get involved, as well as some informational links with the video to all the registrants, and you can share those with your friends. We'll try to format it in a way that's easy to share. Just once again, thank you for joining us, John Erickson, Sarita Fontanesi, and David Donati. I know you're all extremely busy. You have really important work to do. Thank you for taking an hour to talk to our audience, and wishing you the best and good work out there.
Thank you.
Thank you,
Wonderful
everyone.
panel.